Okay, I'd like to call to order the East Lansing City Council regular council meeting of Tuesday, April 22nd, 2025. Could we have the roll call, please?
Councilmember Altman.
Here.
Councilmember Meadows.
Here.
Councilmember Watson. Mayor Pro Tem Singh.
Here.
Mayor Brookover.
Here. Oh, I'm sorry. I can't do two things at once. Hasn't that become obvious for everybody? Okay, and the record should show that Councilperson Watson has arrived. Can we have a motion to approve the agenda, please?
So moved.
Moved by Meadows, seconded by, I'll second that. All those in favor say aye.
Aye.
Aye. All those opposed, motion passes unanimously. We have before us the minutes of the regular council meeting of April 8th, 2025, and the minutes of the City Council discussion only meeting of 15th April 2025. Do we have a motion with regard to those minutes, please?
I'll move approval of the regular council meetings from April 8th, 2025, and from the City Council discussion only meeting of
Okay.
April 15th, 2025.
Moved by Meadows. Do we have a second?
Second.
Second by Watson. All those in favor say aye. Aye. All those opposed, motion passes unanimously. We come to that portion of the meeting where we have communications. All written communications received by council are posted on the online agenda packet. The next item is communications from the audience. Now, I'd just like to say we have a public hearing on what I'll refer to as the housing ordinance, at which people will have the opportunity to speak during that public hearing. So I have a bunch of slips which I think I've interpreted correctly. Barb, do you want to speak at that time or now? Barb McClure, you want to speak? Well, it's your choice.
I'll do it now.
Okay. Liz?
And I'd like to speak early because I have a shiva at 7:30.
Okay. So you're going to cede the microphone to McClure? Is that the way it works here? Okay. Always a mistake to cede the microphone to Barb. Go ahead. It's fine.
I'm Barbara Wall McClure. I know many of you from a variety of things around East Lansing and Ingham County and whatever. My family moved here in 1959. I grew up here in East Lansing, went to high school in East Lansing, went to Michigan State, retired from Michigan State eventually. While I've lived in other communities around the country and around the state, I keep coming back to East Lansing because that's my home. This is where my heart is. It's my understanding, in opinion, that East Lansing would not exist if it weren't for Michigan State University, the first land-grant university, which was granted to give access to high-quality, affordable education for individuals from all backgrounds. I want that for East Lansing now. I want us to be inclusive, not exclusive. As long as I'm living in my home, which is in the Bailey neighborhood, I went to Bailey School, I think I should be able to have whomever live with me that I want, as long as I'm living in the home. I'm not charging rent to anybody. There shouldn't be a definition of family in my mind. Family is what's in my heart. A couple of years ago, I was moving a desk from the main floor down to the basement, and it took me down the steps. Whoops. I fractured my skull. I had a brain bleed. I broke the socket of my eye. Had I had somebody living with me, I wouldn't have been doing that by myself. But I'm terribly independent, as some of you know, and so I was doing that. I worked for the College of Osteopathic Medicine as a development officer at one time, and I retired from the College of Human Medicine. I would like to be able to offer to one of our medical students or a nursing student or a vet student a, quote, scholarship, allowing them to live with me, not paying rent, but share and to be there if I need somebody. I'm almost 75 years old. Did you ever watch Golden Girls? Some of you I know have. There were a group of women who lived together in a house and took care of each other and helped each other and were there for each other when they needed it. I want to be able to do that. I have 3 extra bedrooms in my house. And I would like to be able to offer friends of mine that are at the stage of life that I am to be able to live with me and share cooking and cleaning and be there for each other when we need somebody. But we can't do that now. My cousin's granddaughter is going to be a graduate student at Michigan State. She wouldn't be considered family. It's my cousin's granddaughter. But it's blood to me. It's family to me. And I think I should be able to have her live with me. I don't believe the city of East Lansing can or should define who I consider as my family. They're the people that are close to me, that I care about, that I want to spend time with, and I want to share my life with. And to do anything else I consider discriminatory. And I appreciate your taking the time to listen to me tonight. As I said, I've been an East Lansing resident for a long time. George and I went to high school together. Mark and my dad were in Kiwanis together. Dana and I were on some committees together, so you all know me. You know what kind of person I am. Your husband went to school with me. He was a year behind me, I think. But I just care about East Lansing. And I think we are here because of the university, and we have to continue to remember that. Thank you.
Thank you. Liz Harrow.
Hi, my name is Liz Harrow. I live at 1147 Daisy Lane, and I'm glad that I went after Barb. I loved everything she said, and I actually got worried when she started talking about, I've lived here since I was a child. I went to, because some people, when they come up, they say, therefore, I have more right than anybody else to talk about who should live here, because there is a little obsession in this university town against students. There is a terrible fear of students that's driving us to do crazy things and to waste staff time. And I really worry about what's happening. Who is the staff that's going to be standing in the bushes and counting off personal relations between these people? How are we going to enforce a ridiculous definition of family? And how are we going to keep Barb from telling you that that's her girlfriend who's living with her when it's really just another Golden Girl? We can't do it. It's stupid to write rules that you can't enforce and that are just backward, that are like straight from 1950. Last semester, I had a Nigerian artist staying with me, and she stayed more than the 60 days. And right in the middle of that stay, somebody told me, "Oh, we've made that now. That's legal. You misinterpreted completely the rules, and she would have been legal anyway." I want to keep on having foreign artists live with me through the university, and I don't want any kind of worry about that. My neighbors are African American. They have had every kind of shirt-tailed cousin you can think of staying with them. I never counted how many days, I don't know. But their definition of family is obviously not not the legal definition of family, and I don't think it's right to be, imposing my definition on them. And then lastly, I like this book. This is a book by Ezra Klein. I've been listening to his podcast. I bought copies of it. I want to give them to some of you. And he talks about how, he says, I'm not going to talk about how conservatives screwed up government. I'm only going to talk about, in my book, about the way progressives has stopped progress. And one of the ways that he talks about, his first interest is housing. And he says, we have layered on regulations and stipulations and environmental impact statements. He says, in France, they've had high-speed rail for 40 years. We can't get one even in California, which kind of looks like France and acts like France. They can't even do it there because we have so many regulations. And here we are, still, we haven't gotten the message and we're writing more. I don't understand. Why can't our staff do something more fun? There must be something creative we can be doing with all of our planners. Yeah, that's it. Thanks.
Thank you.
He's my favorite person.
Do you want to address us, sir? Okay. Barb Anderson?
Hi, my name is Barb Anderson. I live in East Lansing. I moved here 5 years ago to teach urban planning and landscape architecture at MSU. I have taught those two subjects at several other universities, including teaching urban transportation planning the years I taught at Ball State University in Muncie, Indiana. I've been a practicing urban planner with nonprofits and a landscape architect for the U.S. Forest Service in Wisconsin. And I've been employed as a consultant with the Wisconsin DOT Pedestrian Bicycle Planning Unit in Madison, Wisconsin, as well as the Land Use Planning Unit at Wageningen University in the Netherlands, where I had the honor to live. And I've written a letter that several people have also signed. Should I read the whole thing?
Well, it's really up to you, but I think we already have the
Yeah.
letter, and I've read it, so.
Basically, it's about speeding in our residential neighborhoods. And I live in Glencairn here, and North Lawn was 2 years ago, I think, repaved, really nice and smooth. But unfortunately, now people go even faster along it because there's there's one or two stop signs, but they just speed along there. And it's just like rush hour in the morning for people taking their kids to school. And so I've suggesting two possible improvements to slow down motorized traffic and roundabouts at two intersections, and narrowing the streets with some curb extensions in the right places. And I can email some photos to you, to appropriate staff. Maybe it would be Stephen. But there's several small roundabouts in Lansing that have been there for a number of years. And I believe the Lansing Department of Public Works staff could speak with the City of East Lansing Department of Public Works staff if they wanted to know how effective those small roundabouts have been, for neighborhoods that are struggling with speeding like we have. I think that's about the gist of it. I'm happy to answer any questions. Thank you for letting me present.
Thank you. Anybody else in the audience want to address us? Anybody in the queue?
There is two callers in the queue.
Go ahead, please.
Going to start with Hilaria, please.
Hi, my name is Ladia, and I am a current MSU graduate student in the College of Social Work and a member of the East Lansing Renters' Right Coalition. I'm here today to speak on behalf of student renters in East Lansing and to support the right to live in a safe, well-maintained homes. I have listened to my friends' horror stories of them traveling from a distance only to arrive in East Lansing to move into dirty apartments with broken windows and locks, and to have their maintenance requests ignored, forcing them to live in conditions that affect their health and safety. Because of my friends' stories and those of renters in East Lansing, we ask you to please adopt an ordinance that would give renters the right to seek repair services for issues on the property and withhold a portion of rent to pay for it. This will allow for important repairs to be done in a timely fashion, and it'll help renters feel free, safe, and welcome in their home and in their new community. Thank you.
Thank you. You have another one in the queue?
1 second. Meg, you're allowed to talk now.
Thank you. Good evening, council members. My name is Meg. I'm a current MSU graduate student in the College of Social Work and a member of the East Lansing Renters' Rights Coalition. I'm here today to advocate for renters here in the city and their ability to live in a safe and well-maintained home. As students, we hear countless stories from our classmates about being taken advantage of by landlords and vital repairs being left for months on end, sometimes never even being addressed, forcing people to live in unsafe conditions because they have to wait for their landlord to get around to their request. As a former East Lansing resident of 8.5 years, I was no stranger to these issues. I was heartbroken to have left my community I have come to love, but I knew it was the right decision for myself. In nearly every apartment I rented, there was a major maintenance issue that was left unresolved for an extensive period of time. From leaking washers, large holes in the ceiling, to 2 of them flooding for at least 3 times in each of those 2 apartments, for over 6 times in total that I had to deal with a flood. In the cases of the flooding, I was displaced for nearly a week each time, lost countless of personal items, and endured insurmountable stress each time. My landlords were either incorrectly fixing the issues or outright unwilling to do so because it cost less to repair the apartments than it did to fix the cause. Only after it became more costly to allow it to continue did it finally get addressed. It was frustrating to know my home and things could be destroyed at any point because someone else refused to take action. No one should have to live in these types of conditions. Because of this and countless other stories, we ask the city to pass an ordinance allowing renters to repair their apartments and have the cost of the repair deducted from their rent. This will give tenants the freedom to fix their apartment and keep them from living in unsafe conditions. And it will also allow landlords to keep their properties more frequently maintained. We want to make East Lansing a place where renters, both students and non-students, can enjoy living and will want to stay and grow this community. Thank you. I cede the rest of my time.
Thank you.
Okay, anybody else in the queue?
There are no other callers.
Okay. Yes, ma'am. I thought you wanted to speak on the ordinance. Do you want to speak during the public hearing, or do you want to speak now?
No.
Oh, okay, go ahead, please.
Okay, thank you. Okay, so first, I really want to thank you all for adding cousins to the list of family members. I really appreciate that. And I just want to say that I totally support the city government in applying limitations on our homes, you know, on homes in terms of occupancy rates, in terms of safety, and in terms of belligerent or criminal behavior. However, trying to define a design enforcement around relationships is a tough challenge. Problem behaviors do not stop, and this frustrates residents on all sides of this issue. Meanwhile, we have to anticipate more acute housing challenges due to disruptions at the federal government level, and not to mention economic and climate crises. I just got back from Altadena, which lost 9,000 homes one night in January. It's a tight community, but the other communities around them took the people in, with no worries, no definitions of family or domestic unit. Many people are still staying with friends. It's going to take 2 years to rebuild some of these homes, at least. What would happen in East Lansing? I can only hope that we would toss our regulations out. It's best to prepare in advance. So please work with the community to prepare a list of reasonable regulations for domestic unit. Definition of terms like permanent nature, housekeeping, cooking, living, these can vary widely. I mean, consider the spouse who, spouses say, and I know they can live together no matter what they do, but consider like 2 people, one works a night shift and one works in a day shift. They are not cooking together. That is just like an archaic way to define these things. City staff should not be forced to decide these questions on the fly. Such a process invites bias against the elderly, the poor, and the disabled. Decisions about who live in our homes and determining the relationships that we value, that decision should rest with the individual homeowners who occupy their homes and not the neighbors or the government. Thank you again very much.
Thank you. Okay, are we all set with public comment?
Yes.
Okay, moving ahead to communications from mayor and council members. Mayor Pro Tem, do you want to go first?
Just a piece that I've been reflecting on since last week in our Arts Commission meeting, and then also last night in the Unity dinner that Mayor Brookover, along with Mayor Andy Shore, sponsored for Ramadan. And Mayor Brookover, I thought, offered some really powerful words about we're all facing a lot in terms of the landscape that we're taking in from a policy front. But community is what bonds us and what will save us. And that really connected with me in reflecting back to the Arts Commission and the work that they've been doing around what's on second reading this evening for Ordinance 1339, as well as the strategic plan. And I mentioned during that meeting, because I was watching members of the community laugh, even though they were going through some tedious language for their strategic plan that will come before us later this summer. But it was really a bonding moment for community members. And I just want to give this a shout out. One, if you're not involved in one of our community boards, please consider doing that. It actually can be fun, and you can make new friends. And it's really important work that benefits our community. And I think there's something really tangible that can be beneficial for mental health and energy and all that good stuff. So, and this may be the only time I mention Mayor Brookover gave a good speech. That's it.
Damning with faint praise. Councilmember Watson.
No, thank you.
Councilmember Meadows.
I just want to make one comment because I want to address your comment about speeding in the neighborhoods. And I was suggesting that as you go through town, you might want to go over to Orchard and Beach, because we do have a small roundabout in that area. So I think it's the only one in the neighborhoods at this point in time. And then about, I want to say maybe 15 years ago or so, because of speeding on Spartan and on Stoddard, if you go down those streets, we have what we called, they aren't speed bumps, they're speed undulations. That's the East Lansing version of a speed bump, apparently. But if you go right at 25 miles an hour, you aren't going to notice anything. But if you speed across it, you know, your car is going to be whacked a little bit. And then on Stoddard, we did a little bit of what you were talking about. We built out and put small islands in the block so that it would slow down traffic. Just take a look at those, and I would suggest that you speak to the Transportation Commission about this, and so they can get this on their agenda and give us some advice with regard to this. But those are very good comments, and we tried to start that up years ago, and it's time to take a look at it again. Okay. Thanks for your comments.
Councilmember Altman.
There is another small island on White Hills Drive, which was installed precisely for traffic calming purposes, so they are scattered around. And then the only other thing I wanted to do was draw people's attention to the recycling containers that appeared magically here within the past month. They were missing from this building, which is a bit inexplicable, and so thanks to Cliff for his work getting future-proof recycling containers around the building. Thank you.
Thank you. I have nothing for tonight. City Manager?
I have no report tonight.
City Attorney?
I have nothing this evening, thank you.
Okay, we therefore move to the consent agenda. Mr. City Manager?
3.1 is approve the following appointments or reappointments to boards or commissions. A is reappoint Pamela Smith to the Library Board of Trustees for a full term ending June 30th, 2030. B is appoint Rose Vadna to the Historic District Commission for a partial term ending December 31st, 2027. 3.2 is consideration of a resolution to vacate the platted public right-of-way between 533 Ardson Road and 535 Ardson Road. Further, set a public hearing for June 3rd, 2025 for determining the necessity and advisability of vacating the platted public right-of-way in accordance with MCL Section 102.3, Fourth Class Act, City Act. 3.3 is approve a resolution recognizing April 28th as Workers' Memorial Day. 3.4 is approve a resolution recognizing May 4th, 2025 through May 10th, 2025 as Public Service Recognition Week. 3.5 is approve a resolution recognizing April 21st through the 25th, 2025 as National Community Development Week. 3.6, approve a conditional Class 3 rental license for an occupancy of up to 2 unrelated persons or a family at 1015 Short Street. The owner of record is Anthony Grant, Ann Arbor. 3.7 is approve a contract change order with Bearstone Construction LLC for the 2024 through 2026 miscellaneous concrete project in an amount of $75,000 and authorize the city manager to sign. 3.8 is approve a contract with Colliers Engineering for the Trowbridge Signal Construction Engineering and Inspection contract in an amount of $97,000 and authorize city manager to sign. 3.9 is approved to distribute the draft comprehensive plan update document for public review and comment. 310 is approve a street closure for Linden Street between Abbott Road and Park Lane for the City Hall roof replacement project from May 19th to June 2nd, 2025. 3.11 is set a public hearing for May 13th, 2025 to consider the fiscal year 2026 Community Development Block Grant budget. 3.12 is set a public hearing for May 13th, 2025 for a preliminary fiscal year 2026 budget and property tax rate. 3.13 is schedule a public hearing for May 27, 2025 to receive comments on a request from Matt Levitt on behalf of Meyer, Inc. for approval of a special use permit located at 100 West Lake Lansing Road. The applicant's request is to construct a 5,751 square foot gas station with 6 gas pump islands and 12 pumps. The property is zoned B2 Retail Sales Business District.
Do we have a motion?
I'll move approval of the consent agenda as presented.
Moved by Mr. Meadows, seconded by Ms. Singh.
I do have a question or two, if I may. With regard to item 3.2, I assume there's a statutory or ordinance basis for this process, is that right?
City Attorney?
Sure, yeah, that's correct. And in this particular situation, it's just a alley that's actually acting, it's a driveway. And so this is the standard process we've used previously.
Okay, it doesn't mention the statutory basis or the ordinance basis, just for future reference. I think that would be helpful to have in one of these so the public would be fully aware of that. That's my only question with regard to that.
Are you saying something else other than MCL section 102.3?
I didn't see that in there, but it was.
That's at the end of the thing. All I'm trying to find out is if you're thinking there's some other ordinance or statute that applies.
Was it? No, I do not. Is it in the report or in the actual resolution?
It's in the agenda,
Yeah,
MCL section 102.3.
I think it's not in the resolution.
Okay.
That's what I was talking about.
Okay, thank you.
And then with regard to 313, just a question on why so long before the public hearing on this? The Planning Commission made the recommendation or non-recommendation a couple of weeks ago. I can't see why we'd be waiting till the end of May to do a public hearing on that gas station. Is there a reason we have to do it this long?
City Manager, can you speak to that, or City Attorney?
Actually, I'm just asking Landon to come up and speak to that.
Reason for that is that the Planning Commission made a recommendation, I believe it was April 9th, due to public notice requirements. Excuse me, the next available council agenda we could get the scheduling of that public hearing on would have been tonight. And then due to public notice requirements, the next available meeting for that public hearing would be the 27th.
Okay, that's all I needed.
But I'd love to speak more about this in the business agenda tonight when we
Yeah,
talk about
got it.
policy resolution 2025 too.
Got it.
Thanks.
All right, thank you.
Had to get your shot in, didn't you?
Mayor, I have a question.
Yes, sir.
Also about item 3.2. The resolution that's on the consent agenda, are we actually vacating the platted public land, or are we doing that after the hearing?
City manager?
My understanding it's after the public hearing.
Okay, so we're not actually taking action on it tonight.
Right.
All right, thank you.
Good question, thank you. Okay, are we prepared to vote on the consent agenda? Did we have a motion?
Yeah, we already have.
And we had a second?
Yep.
All those in favor say aye.
Aye.
All those opposed? Okay, we then move on to a public hearing, item 4.1, a public hearing in accordance with ordinance number 1206 for property owners in the fiscal year 2025 hazardous sidewalk project area to contest the need for sidewalk repairs, further consideration of a resolution to order the repair of sidewalk at the locations included on the list attached to the request. Staff.
Good evening, Council. My name is Stephen Clayton. I'm with the Engineering Department of Public Works. Next to me is Joseph Callahan. He's our newly hired, recently hired, I should say, project engineer for this project. Before you is a public hearing for the this year's hazardous sidewalk program. It's in accordance with Ordinance 1206, and further to consider the resolution to order the repair of the sidewalk at the locations included in the agenda item. This program is kind of a yearly program. It was established back in 1999. It was updated in 2008 through approved ordinance number 1206. I think the recent criteria was adopted 2016, which is attached to that agenda item for the recent criteria, which our staff uses when they go out and rate particular neighborhoods for hazardous sidewalk. They look for things like cracks in the sidewalk, vertical displacement, eroded surface, and excessive cross slope greater than 4%, those kinds of things. So this year, in accordance with the program, they went out and assessed. They sent out letters in November of last year. So each of the property owners was notified. They had an opportunity to reach out to staff and schedule a meeting with staff in accordance with that program. Attached to that agenda item are all the addresses that met with staff. These are the addresses that reserve the right to appear before council according to the program. So if they wanted to appear before the council with this public hearing, they had to first meet with staff, and that's what you see there is the list that have reserved that right. So again, in that agenda item is a list of all the properties that were assessed and the amounts that they were assessed. It's a not to exceed amount. It's based on previous unit pricing. It also includes some of the city, the sidewalk that the city is responsible for. So any damage that's caused by trees is the city responsibility, according to the same program. So, this public hearing is to allow those property owners that are listed to present before council to contest the assessment or the program in general. And so with that, staff is here to answer any questions and to attend the public hearing and to recommend the adoption of this program.
Okay, before I open the public hearing, I have a couple questions for you.
Yes.
So in the staff report, 1, 2, 3, fourth paragraph down, it says the Department of Public Works held the administrative review from Monday, February 3rd, 2025 to Friday, February 7th, 2025 from 8 a.m. to 3 p.m. Property owners who were unavailable to appear at the above times preserved their right to be heard. This list that we have tonight, are those people that A, either appeared or B, did not appear but requested the right to contest?
Correct, yeah, and a lot of these, I think the majority of these people that are listed actually met outside those, in full disclosure, outside of those time, the February 3rd to February 7th, but they did request a meeting, so staff would
Okay,
met
so
with
your
them.
representation to us is that those people who you've listed, or those addresses you listed, have in fact had contact with you and have requested the right to appear in front of the council, correct?
Correct.
Okay. And then my second question is, did they in fact receive written notice of tonight's public hearing?
That would have been in the original letter sent out, yes. So
Okay.
that original letter that they received outlines all the process and the dates and everything.
Okay, and
And
it gives
includes
them
a
the,
response.
and it gives them the date of tonight as the public hearing?
I did not include the date of tonight as the public hearing, no.
Okay, and my third question is, you've listed an address on here called 33 University Drive. And then when I see the itemization of all the lists, I don't see 33 University Drive unless I'm missing something. Is there a 33 University Drive?
I see it.
Tell me where, please.
Is it on there?
About the fifth line from the bottom.
Ah, stuck with 330, okay. All right.
Right here.
Mr. City Attorney, do we have the statutory / ordinance right to pursue a public hearing in this without giving the objectors written notice of the date and time of the public notice, or the public hearing?
So, this is a process, this is an administrative appeal process that we've done for many years. I'm sure this is consistent with how we've previously done it. But let me get into the ordinance one moment.
Well, you know what, regardless of what the ordinance says. Go ahead.
My suggestion is that to defer action on this and to reschedule a public hearing for the first meeting in May and give proper notice to the properties listed.
And does that require a motion to defer or table?
Yes.
Okay, defer or table?
Motion to defer the public hearing to that date, sir.
Okay, I move to defer the public hearing to that date, and in addition, that the city government is responsible for sending written notice both via first class and certified mail to those addresses and/or householders. That's my motion. Second from Meadows. Any discussion? All those in favor say aye. Aye. All those opposed? Thank you, gentlemen. Appreciate it. Okay, the next thing on our agenda is a public hearing to receive comments on ordinance 1545, an amendment to the definition of family. In Chapter 50 zoning of the City Code of Ordinances. Staff.
Thank you, Mayor. Landon Bartley, Principal Planner. Ordinance 1545 is a proposed amendment to the zoning ordinance that would amend the definition of family. Ordinance 1545 was introduced by this body on January 7th of this year. That was introduced and referred to the Planning Commission. The Planning Commission subsequently held a public hearing on February 26th of this year, at which time they received verbal comments, verbal and written comment from one individual. The Planning Commission, again, considered the amendment at their meeting on March 12th, at which point they once again received public comment, verbal and written comments from 3 individuals, 2 in person and 1 by phone. I should mention the Housing Commission also hosted a meeting on February 6th, at which time they received comments from 2 individuals, and they made recommendations generally in support of the amendment as proposed, they have a letter in the packet from the Housing Commission. And then finally, the Age-Friendly Committee of the Seniors Commission met last week on Thursday and also received comments from 2 individuals about the proposed amendment at that meeting. The amendment, as I mentioned, would amend the definition of family within the zoning ordinance, essentially adding the words foster children, persons living with dwelling unit owner under guardianship, and cousin to the definition. I'm happy to read the current definition as it's written today as well, or can take any questions about what's proposed tonight.
Okay,
And
questions
again,
for
this is a
staff?
public hearing.
Yes, Ms. Wanson.
For tonight.
Just one comment. I don't know if it's not talking to the microphone or if they just need to be turned up, but I'm just having trouble hearing today, hearing as much. Okay.
I'm sorry, I'll
Thank
make
you.
sure to direct my
Thank you.
voice in.
Okay, questions for staff? Okay, I therefore declare the public hearing to receive comments on ordinance 1545, an amendment to the definition of family in Chapter 50 zoning of the city's Code of Ordinances, to be open. Are there members of the public that want to speak? Mr. Grebner?
I'm Mark Grebner. I'm a 55-year resident of the city, I think. I was first elected county commissioner 48 years ago. I live at 615 Glenmore. A couple notes about myself before I talk about law. First, you may not know that 30 years ago, I was involved in exactly this same controversy about the definition of family. I wrote a charter amendment that prohibits the city of East Lansing from discriminating against anyone on the basis of marriage or family status. That charter amendment was placed on the ballot. It was adopted by the voters. It is included in the charter, and the city simply sidestepped it, and it has never been followed since because it was declared to be unimportant and nugatory. So I'm sort of still on the same point 30 years later. Okay. Second, I'm an attorney, sort of. I've never practiced law to speak of, but 10 years ago, I came into my office and discovered a friend had been charged by the city with illegal renting and had received about $20,000 in tickets, although she had never had a rental and had no tenants and had never received any rent. That launched me on a very small legal career since then, in which I've represented about 30 people in the face of East Lansing's housing ordinances, and I have done my best to throw sand in the gears over the last 10 years, but that is my entire law practice, such as it is. Finally, the proposal that's before us today doesn't affect me personally at all because I simply threw up my hands 8 years ago because I just couldn't figure out how to navigate the definition of the alternative entity, the family thing. So I just got a rental license. And so I live in a condo with a couple people who don't really pay rent, but I don't care. We'll pretend they're tenants. So I solved it that way. I don't know that it's sensible for other people. So let me rush through a very brief introduction to law. There are 5 cases to know about in having to do with families and zoning. First, Euclid versus Ambler Realty was the big case by the U.S. Supreme Court in 1926 that said zoning was legal. You could actually have zoning. So zoning law only goes back just under 100 years. But the question was, can you zone only for allowing families to live somewhere? And in 1974, the U.S. Supreme Court answered that question in Belter versus Boris. These cases are easy to find if you just Google them. So yes, you can limit a zone to families only, not unrelated people. Then the question is, what is a family? In the case of Moore versus East Cleveland, another U.S. Supreme Court decision in 1977, said the city of East Cleveland cannot define family, okay? And if we quote, I may run out of time here, but ours is by no means a tradition limited to respect for the bonds uniting the nuclear family, or limited to respect for it. The tradition of uncles, aunts, cousins, and especially grandparents sharing a household along with parents and children has roots equally venerable and equally deserving of constitutional recognition. That's from the plurality decision. And so Moore versus East Cleveland says East Lansing's ordinance is unconstitutional. You can't have a limitation to specified legal relations. You just can't do it. It has always been illegal. Your definition of family has always been unconstitutional. Then, finally, the fourth case is that so the U.S. Supreme Court says families are defined within legal relationship. A city can say only people who have a legal relationship can make up a family, but within that, cousins or step-cousins or half-brothers or whatever is beyond your reach. But in Michigan, there is a further case by the Michigan Supreme Court called Delta Township versus Dinolfo, which said that's not the law in Michigan, because under the Michigan Constitution, we have additional rights. And the additional right in Michigan is that family does not have to follow legal relationships among people. Any group of people living together who live as a family are a family. And so you cannot define family other than by saying whatever Dinolfo has in its language.
30 seconds remaining.
So I would recommend two courses to bring this into conformance with the state constitution and the federal constitution. One answer is use the word family in your ordinance, but don't define it. And the other alternative is use the word family and define it by taking language from Dinolfo versus Delta Township. And I don't know what it means, but there's a lot of nice language about people living together and sharing responsibility in a household. Thank you.
Thank you. Mr. Rose?
Thank you. My name is Patrick Rose, 310 Oxford Road. I'm here to voice concerns of a large number of East Lansing residents. Each of them told us over the last 16 months their family living arrangements are declared illegal under city zoning law. We promised them we would come after our charter amendment passed to ask you to stop discriminating against families who have a constitutional right to live in a single family dwelling. The city zoning law declares their occupancy illegal in ways that are lawful under the Michigan and the U.S. Constitution. So our ask is vote no on 1545. Do not reenact an unconstitutional ordinance. Start over. Our lawyers committee drafted a constitutional definition of family. Please adopt it instead of 1545. A further hearing will show East Lansing zoning law violates the U.S. and Michigan Constitution's biological and functional family test. Now, this is clear for 4 reasons. First, the U.S. Constitution limits a city's power to define a family to close blood relatives that excludes a range of blood relatives. You're required to include them all. That's the Moore versus East Cleveland case. And the court held that when East Cleveland told the grandmother with 2 sons and 2 grandsons, a child of each of her sons, that she had to tell one of the grandsons they had to leave the house, that violated her rights under the U.S. Constitution's 14th Amendment due process and equal protection clauses. This city does that with great aunts, with half siblings, with second cousins. Cousins were required to be in there from the beginning. It's in the decision. So from 1977, you couldn't exclude cousins and you couldn't exclude nephews. I almost got 14,000 in fines for having my nephew. Second, why we know this is unconstitutional, the city zoning law does not allow functional families to be a domestic unit, even when they have protection of the Michigan Constitution to live together. Pay close attention to my next point. The domestic unit test excludes them by category. It excludes any group, that word's excluded. Any group is any alternate family, any association, any combination of persons, any coterie, which is persons living together as a household in a cottage. These 4 categorical exclusions are designed to exclude all functional families. This is the opposite of what the Michigan Supreme Court said you must do to protect families in Delta Township versus Dinolfo, the 1984 case. Third, the burden of proof to qualify one's functional family as a domestic unit is clear and convincing evidence. That is an unconstitutionally high burden of proof. It's only in the law for libel and fraud cases to make them hard to prove. The Michigan Supreme Court said you cannot set up an obstacle course that no one can get across, so they try to reclaim their fundamental right with this kind of a high standard. What am I saying about domestic unit? I am saying it is an unavailable, empty, meaningless category not available to anyone. Fourth, we confirmed Thursday at the Age-Friendly Committee it doesn't exist. The city doesn't let people apply. They don't give them a hearing. They can't prove it to meet the standard. There's no appeal from a denial. The city won't even promise citizens it will ever determine if they qualify until they receive rental housing fines to punish them for having a protected status. The Michigan Supreme Court ruled, and I'm quoting, that a zoning ordinance which prohibits the defendants from including in their household 6 unrelated persons is unreasonable and arbitrary and violates the Due Process Clause of the Michigan Constitution. It would prohibit 5 unrelated widows, widowers, old spinsters, or bachelors, or even of judges, 4 or 5 living together in a 5-bedroom house from residing in a single unit within the municipality as a household, as a family. The court said you cannot prevent 3 retarded children from living with a married couple. They gave example after example. You clearly violate them. What they said you could do is prevent students, transient occupants, seasonal group houses. This is not about
30 seconds remaining.
This is not about stopping students from living in neighborhoods. This is about protecting families and protecting our taxpayers who will pay for your mistake if you do not fix this ordinance. A federal judge ordered East Lansing to pay $825,000 for violating the apple farmers' right to free speech. Enough is enough. We don't want to pay for your violations of people's constitutional rights to live with their family. Hands off our families.
David Hopkinson.
Retired Judge James Giddings couldn't be here this evening, so I'd like to read into the record his letter.
You know what, we have his letter, and...
I'd like to read it into the record.
Okay. Are you a resident of East Lansing?
I live at 1736
Okay.
Roseland Avenue in East Lansing.
Because Judge Giddings is not a resident of East Lansing, that's why I'm
Okay,
inquiring. So
that's reasonable.
Go ahead and read.
This is his letter of opposition to the reenactment of a zoning ordinance that denies East Lansing residents constitutional rights to live with members of their family. Dear Mayor Brookover, City Manager Bellman, City Council members, and City Attorney Chubb, we are members of a community group that supported the passage of Proposition 1. As you know, Proposition 1 protects East Lansing residents' right to have live-in guests without those guests being presumed to be a tenant after 30 days, and without fear of fines imposed without advance notice. The Charter Amendment did not change East Lansing zoning code definition of family or domestic unit. Adoption of Ordinance 1545 with its narrow and unconstitutional definition of family is not necessary to implement any part of Proposition 1. The U.S. and Michigan Constitution protects members of a traditional biological or nuclear family and of a domestic unit more broadly than does this zoning code. We urge adoption only of ordinance language that conforms to the requirements of the state and federal constitutions. To follow this request, the City Council should decline to reenact the definition of family domestic unit in Ordinance 1545. To enact the family domestic unit definition violates basic rights of East Lansing families. We propose an alternative course of action below. We ask the City Council to adopt an amendment to Ordinance 1545 to assure that the city's definition of family domestic unit meets the constitutional tests set forth in Michigan Supreme Court and U.S. Supreme Court decisions in Delta Township versus Donalfo and Moore versus City of East Cleveland. The current East Lansing zoning code definition of family domestic unit that Ordinance 1545 reenacts with minor changes is so narrow that it violates the constitutional rights of biological families and alternative families to live together and share costs. It limits biological families too strictly in ways that clearly violate more, and it limits the type of functional families the Michigan Supreme Court in Denolfo said the city has no constitutional power to define as unlawful inhabitants of single-family homes. We believe that adopting Ordinance 1545 and reenacting the existing unconstitutional city zoning code definition of family violates our shared commitment to following Supreme Court decisions interpreting the state and federal constitutions and rule of law. If the council deems it necessary, we would ask for a legislative inquiry into whether the proposed ordinance 1545 violates the Michigan and U.S. Constitution. No such hearing has occurred, with alternative language defining family domestic union under review that meets the constitutional test. Neither the City Council, the Planning Commission, nor the Housing Commission has afforded a fair opportunity to craft a constitutional change to the zoning code definition of family. We have asked for a hearing on our proposed constitutional version of the language of Ordinance 1545. Our proposed amendments were not considered by the City Council or the City Attorney or by either of the commissions. Our constitutionally satisfactory alternative ordinance language defining family domestic unit was not put on any agenda or voted on. As a result, the City Council has not heard from members of the community who want to expand the family domestic unit definition so it protects their rights that are violated by the unconstitutional language in Ordinance 1545. By adopting Ordinance 1545, East Lansing would be denying biological and alternative families the right to live together and share rental and household expenses, rights they now enjoy under the Michigan and federal constitutions. Proposal 1 only protects the rights of persons who are not rent-paying tenants. Proposal 1 did not change the zoning code. In closing, council should not reenact the city's unconstitutionally narrow definition of family domestic unit. To do so would deny basic rights and create liabilities for city taxpayers. To reenact the existing unconstitutional definition of family domestic unit in the zoning code violates our shared values as a community to protect family and uphold the rule of law.
Thank you for reading us retired Judge Giddings' letter. Okay, anybody else want to speak during this public hearing? Seeing none, I declare the public hearing closed. The council can choose to take action or no action at this point, I think. Mr. City Attorney, is that correct?
That is correct.
Mayor,
That is
I
correct.
have some questions. I have some questions
for
staff
Sure.
and also a comment.
Sure.
So first, in terms of the process, I want to suggest and request that we consider 1547 together with 1538 and the ordinance that would remove a bunch of stuff from Chapter 6, which we're going to have a first reading on later in the business agenda, that we consider those three ordinances in a single motion at the same meeting because they are interrelated. And if we consider them separately and one or more pass, but one or more fail, then we end up with the potential for having a mess in our ordinances. So that's a technical term. So I'd like to suggest in terms of process that we arrange in the future so that all these three ordinances are considered in the same motion. So that's a process comment. A couple of substantive questions for staff. So one of the things that 1547 would do is it would move nieces and nephews from where they are currently, which is Chapter 6, into the zoning code, which is Chapter 50. all sorts of other relationships are already in Chapter 50. So my question is, can anybody reconstruct how nieces and nephews ended up by themselves in Chapter 6 when the rest of the definition of family ended up in the zoning code? And is that just in my head?
No.
Yeah.
Okay.
It's just in your head.
There's a lot of things that are just in your head,
I
Eric, but
worry
not
about
that.
that.
Not that.
I worry about that. And associated with that is, are there any unintended consequences of moving nephews and nieces from Chapter 6 to Chapter 50?
Okay, and would it be appropriate to have staff get back to us with a memo on that?
Sure,
On those things?
that'd be great, unless they're able to address it now, but comments for the next meeting would be great on that.
Yeah, I would suggest maybe we do it that way instead
Okay.
of
And then,
flying blind on that.
yep, and then also, the addition of cousin would be a new dimension, and I have questions about that. I'd like to know if staff has any concerns about enforcement associated with adding that. I'd also like to know what cousin means. Does it mean first cousin, second cousin, nth cousin, cousin once removed, cousin twice removed? Is there a legal definition of cousin that we can work with? And then I guess my last question is, does anybody know how long the definition of family has been in our code largely as is? My assumption was that it's been in there for about 25 years. But if anybody has a date for when that was added to our code, that would be interesting, because if we've been unconstitutional, then I'd like to know how long a period people have had an opportunity to sue us.
Okay, any other questions for staff?
Mhm.
Yes.
What Commissioner Grabner remarked on a petition that was placed on the ballot and passed and not abided by, I would like to see that information as well, please. And I want to make some comments.
Well, let me just answer that question.
Yeah.
Mark and I were both part of that charter review, and it's in our charter. So the question then is,
Actually, Mark.
Oh,
and
yeah,
you
Commissioner
were all part of
Grabner.
that charter review.
I get it.
I get mixed up. Anyway, and so that's in the charter. The question is, how has it been enforced or unenforced? So
Okay. May I see that part, please, of the charter to highlighted and brought back next time? In my comments, hearing from the public about issues with the definition of family, I'm curious about who out there would say that they benefited from a definition of family in their home. And so I'm not sure throughout this entire time that we've really heard from those group of people, because I'm wondering if they exist. Oftentimes we think about these days even more is following the money. And so our council recently passed an increase in our PACE officers with the argument that we could gain revenue by handing out tickets to people. And our council, prior council, we approved the franchise fee, which gave us money, which in turn was problematic. And so now I'm curious, is this to give us money? Is this in place that we're meddling so much on who's staying at whose houses because that gives us money as well? I can't figure it out. And I saw someone shaking their head. So the other part is it in place for discrimination to happen? For the people that don't like seeing same-sex people, that don't like thinking that I might refer to someone that's not related to me as my cousin and they might live with me. And what's the harm? And again, if it's not the money, is it to uphold something that we think doesn't exist in this community, that we don't want to abide by in this community, which is discrimination, anti-Black, anti-Semitic, homophobic, preserving the nuclear family. What is this really all about? And so definitely in favor of slashing a bunch of things out. I'm not hearing from the people who benefited in this community, and I am concerned that this is once again maybe just about money and hopefully not just about discriminating against people that you don't want to live next door or you don't want to be in homes by you. Thanks.
Okay, anything else at this point? Right, if there's no action of council, we'll move ahead to the next agenda item. And I think we're to the business agenda now, unless somebody corrects me. Item 5.1, first reading of Chapter 6. Do we need staff on this or not? Please.
Good evening. Before we start with the first reading of Chapter 6, I do want to introduce Elise Hodges to you all. Elise started with the city in December as the new Housing and University Relations Administrator and has been doing a great job working in our office, staffing the University Student Commission as well as the Housing Commission. So before we begin, I did want to take a moment to introduce her this evening. So before you this evening is the first reading of Chapter 6. Chapter 6 currently is in our code. It's titled as the Building and Building Regulations. And this we had got into this. This is where the rental regulations have been housed for many years now. And in an effort to have all of the rental regulations in one area to hopefully make things easier for everyone, we have extracted all of the items related to rental licensing or rental regulations out of Chapter 6 into the new proposed Chapter 7.
Ordinance 1538.
Yes, thank you, which you all have seen and we'll see again. And so now this leaves what's left with Chapter 6. So we have that before you this evening as a first reading of that. And happy to answer other questions if you have them.
All right, let me just ask you this. So we have in front of us a red line, and what I assume is an original or the...
There's a clean copy and a red line copy.
That's just what I was going to say. Thank you. And so am I correct, deferring to Mr. Altman, but am I correct that the purpose of this tonight is to have a first reading of this Chapter 6, which would now be modified to extract from it all of the rental housing matters, so that what would remain was the original or the zoning provisions without the rental housing stuff in it?
This is just the building.
I'm sorry, building.
Building.
My
Yep,
mistake.
so it's just the building that's left.
Okay.
And all the rental will be in the new Chapter 7, 1538.
Okay. And so as I go through this, between this first reading and the second reading, is there any other redlining other than things that dealt with the rental housing regulation?
No.
No.
Okay. Mr. Altman, did you have a question on this one, or you just wanted to consider it at the same time?
I wanted to make sure that what's before us right now, first reading, plus Ordinance 1545, which we just had the hearing on, plus Ordinance 1538, which is with the working group, are part of one motion. because they are interdependent.
I understand, but my synopsis of this particular ordinance coincides with your understanding as well?
It does.
Okay, thank you. Any other questions for staff?
Yeah, to accomplish what Eric wants to do, he could make a motion like that at a future meeting as long as we have all these things on the same agenda. So I think that's just the key there.
I understand, yeah. Okay, any other questions for staff? All right, thank you.
Thank you.
Oh, I'm sorry, go ahead.
I just want to, Elise, welcome. And I just, as the liaison to University Student Commission, your energy with that group is really beneficial. So I just want to thank you and welcome you. Thank you, sir.
Yeah, I'm sorry.
No, you're good.
Okay, item 5.2, second reading of ordinance 1330.
Actually, I think the mayor, the city attorney is going to indicate you need a motion on 5.1.
To defer.
First reading.
I'm sorry, say that again?
I don't believe we made a motion to approve the first reading for 5.1.
I move we approve the first reading of Chapter 6.
Second.
Any discussion? All those in favor say aye.
Aye.
All those opposed, motion passes unanimously. Second reading of ordinance 1339. Now, before we get going on this, Dr. Altman, I'm not as numerically talented as you are. Is this one of the ordinances that you were talking about or not?
This is completely unrelated.
This is, okay.
This is the Arts Commission ordinance.
Yeah, okay, thank you. Staff, please.
And I am with the Art Festival, Arts Stewardship and Coordinator for all of those things. I'm here today as the liaison to the Arts Commission for the second reading of the changes to Ordinance 1339. You've heard from me a couple times now, but we made these changes to help expand the definition of art, clarify allowable expenses from the Public Art Fund, and bring the ordinance in compliance with the zoning code. I'm here now for the second and final reading, hopefully, and happy to answer questions. And I'd like to ask that council formally adopt the amended ordinance 1339 tonight.
Okay, any questions for staff? Okay, thank you.
I have a motion
Okay,
that we move forward and approve the amended ordinance of 1339.
is there a second?
Second.
Okay, I'd like to move to amend the pending motion to add back in section 2-312, paren A, paren, the last 2-312, paren A, n, paren, the last line, which has been stricken in this version, which says, quote, "No public art from public funding may be placed on private property." And then I'd also like to amend item 2-313A to delete in the new version, I'm sorry, 2-313A, paren, I'm sorry, 2.2-314, paren A and paren, sub-paragraphs 11, 12, and 13, and in that same section, sub B, to delete the language in sub-paragraph paren 2 and paren, quote, "However, musical instruments may be included."
I lost you on that. I'm
Yeah,
sorry.
how about if we do these one at a time? How's
Yes.
that?
Okay, fair enough. So my first motion to amend would be to add back in to section 2-312, paren A and paren, the language, quote, "No public art from public funding may be placed on private property," end quote. Is there a second for that motion?
For discussion purposes, I'll second.
Okay. I don't think that we ought to be using public money to place art on private property. I think we get into a definitional construct problem in terms of what private property And I just think it's a bad precedent to set where we're using public money for private property. And I think, for want of better terminology, the due process portion of that is ripe for confusion and discord. So that's the reason for me making the amendment.
I have some questions.
Sure.
So I had the same question when I read it during the first reading, because that was sort of my impulse also. But I think that during the discussion, we talked about this, so I wonder if people could address this.
Yes. Should I, or do you want to?
Sure. Well, I believe it was the thought of the commission that if you look within the definitions, the definition of public art was inconsistent with that provision that was stricken, in that the public art definition reads, "a means works of art purchased through the Public Art Fund or through the public art requirements of Section 50-38 sub 6 of the City Code that are located in highly visible public areas or private areas that are highly visible from public areas." And so there was a seeming contradiction between those two statements.
It was also a duplication. I believe the commission felt that we cover the definition prior in the ordinance.
Yes. And in the two examples that I have been a part of, we have created easements with the private owners.
Okay, can you just tell me where those are?
The greetings tour mural on the Roadhouse pub, and then the mural on Beggar's Banquet in the alley.
What about the seated lady in the 600 block of Grand River? Isn't that sitting on the property of, I think Robert Phipps owns that area?
I'm not
is that on
familiar
private
with
property
that.
as well?
I'm not familiar with the origin of that one, so.
Okay.
Isn't
I think
there-
we've done this before, is my point, but on private property, where the public has access to it.
Mm-hmm.
Isn't there another one above the entrance to the Abbott Road garage? Isn't there a mural there also?
The one of Robert L. Green?
Yep.
Yes,
So that's also, that's on the parking garage?
that's on the parking
Okay.
garage. Yes.
So the definition includes, the definition essentially requires that if it's on private property, it has to be highly visible from public areas. And so in that sense, it's a way to facilitate public access.
Yes.
And I know that we've had private contributions for some of the public art that we have, and that may be on private property as well.
Yes.
Okay, Mr. City Attorney, do we vote on the amendment first?
We need to vote on the amendment first, yes.
Okay. All those in favor of the amendment say aye. Aye. All those opposed?
Aye.
Okay, the amendment is defeated. I then move to amend Section 2-314, paren A, end paren, subparagraphs paren 11, end paren, 12, paren 13, end paren, 13, end paren. And, well, I'll make that motion first. Is there a second for that motion?
I'll second. I'd like to hear, because I would like to hear the maker of the motion explain the motion.
I don't understand why we would be paying for performances or writings or for public teaching of artistic skills separate from what could happen in this facility here, or purchases of musical instruments consistent with public art. It seems to me that artists who are willing to engage in those particular activities for the public good are well-equipped to provide those instruments of their art on their own without the public paying for them. Frankly, I don't understand I don't even understand how we would pay for musical instruments. I assume in an artist that a musician will have access to the musical instruments that artist utilizes in his or her performances.
So just for clarification, your motion is to remove paren 11, paren 12, paren 13, renumber 14 and 15.
Thank you, yes, correct.
Okay.
Yeah.
And I support that. I look at it and I feel that the commission has had some challenges in expending public money, the limited money that we have actually provided for the type of art that, and that's probably a bad way for me to phrase it, the art that the community expects, the visible, usable, visitable art that we have scattered throughout the community, and I think we need to concentrate at this. And I think we have other options for 11, 12, and 13 that wouldn't drain those resources or reduce those resources going forward, and so I support your motion on that basis.
Other discussion?
Could I ask staff to address the issue?
Yes. So on musical instruments, it wouldn't be like buying someone a drum set or a saxophone. Specifically, what was discussed in the commission meetings was a kind of a sound garden instruments. So there are a few places in the greater Lansing area that have, I don't even know what they're called, musical instruments, I guess. So they're like next to a garden, and you can like talk into them, and your voice is amplified so you could sing. Or there's xylophones that you could play next to a playground, or there's even some at a local library that you can, they like chimes, and you can interact with them. So it's just a way for people to interact with art in a different way. And oftentimes these pieces are pre-manufactured. They're not made by an individual artist, but a company manufactures them. And that's part of what we're amending, is the ability to buy manufactured art. That would also give us the ability to have possibly a creative or different kind of play structure on a playground too. Not necessarily music related, but it would be pre-manufactured in an artistic way and installed in a playground. So it opens it up to more possibilities that we are unable to use at this time.
Well, all which is pretty cool stuff, but we don't have a definition of musical instruments. So, and we may not have you around in 7 or 8 years to tell us that the history of musical instruments includes that, which I think the way you define it is to the exclusion of things like French horns, violins, violas, et cetera, et cetera, et cetera. So my concern here is we lack definition. Go ahead, Mayor Pro Tem.
So I just want to take us up 100,000 foot on one of the reasons, or I should say two of the big reasons the commission went through this process is, one, there was repetitive and unclear language within the ordinance that they felt needed to be cleaned up. Secondly, this is an outdated definition of art, and unfortunately they could not create grants to support artists that were into performance arts or music, etc. Their definition of public art has been brought into alignment with a number of the federal definitions and what they could grant make to. And I would say to my colleague that brought up The commission has not had any trouble dispersing grants. They've had twice as many grant requests than they've been able to fulfill. But again, this is about what the community is seeking, including having kids interact with art in our public spaces. It brings a huge opportunity, and I fully support all the amendments to the ordinance as presented.
Well, and everything you said was exactly correct. But the problem is, in these ordinances, the devil's in the details, and that's what I support the public art concept, and I support everything you just said. The question is, what's the standard that we're using for the definitional construct for the use of public money? So, any other discussion?
Would you like to propose a specific definition of what a musical
Not-
instrument would be?
No, because I don't know.
Okay, well, you didn't ask the question when we had our first hearing either, Mayor.
That you're absolutely correct. All right, any other discussion? Go ahead.
Can you repeat the motion for me, please?
Yeah.
What you're amending?
Amending section 2-314 to strike subparagraphs paren 11 end paren 12 end paren 13 end paren, and then renumber paren 14 end paren as paren 11 and paren 15 end paren as paren 12.
I do have one further question.
Sure.
So the 11, 12, and 13 are somewhat different character, it seems to me. 11 and 12 group, and then 13 is a bit separate, right? And so I guess I have two questions. One is about 13. The musical instruments that you mentioned, it makes sense to me that they're basically part of an installation, right?
Right.
So then, wouldn't the instruments be part of the art?
They would be the art.
So then why wouldn't they already be covered? Why do you need a special provision for musical instruments?
Because we cannot purchase pre-manufactured art pieces.
Oh, I see.
Yes.
Okay. And then could you address the rationale for 11 and 12? Does that also fall within the it doesn't seem like it falls in with an updated definition of public art, but perhaps I'm wrong. But if you could address the rationale for those two, that would be helpful. Thank you.
Can they be read to me? I do not have the.
It's the fees to artists for performances, et cetera, and fees to artists for the public teaching of artistic skills, et cetera.
Okay, so yes, those are different. The Public Art Fund currently does not allow for us to expend funds on teaching, workshops, events, unless there is a permanent piece of art that that remains behind as the city owned. And when we put out a survey to the East Lansing public asking them what they would like to see in their community for art, there was a large number of individuals who wanted to see more opportunities for art education. And so the commission heard that, saw that, and included it in the update. Currently, the only way that we can fund events or workshops are through the cultural arts grants that is a part of the general fund allocation to the commission. But it is a limited amount of money, whereas the Public Art Fund has a little bit more in its coffers.
Okay, any other questions or discussion?
I do have a question based
Sir.
on a comment that you made. You said you can't purchase pre-manufactured art pieces, and that would be the reason for this, but where is that in the ordinance?
That's in section 3.3. Hold on one second. It's section 314 sub B sub 2, which creates as an exclusion are objects which are mass produced or of standard designs, such as playground sculpture or fountains.
But how would that prohibit the purchase of these musical instruments in the manner they were described?
Because they would
They are
be,
not mass-produced.
the way that these types of Soundgarden instruments are made is mass production.
Well, maybe we ought to look at changing that as well, so.
So now I have a question, which is the amendment to paragraph 2 that the city attorney just read now, as amended, will include musical instruments.
Right, so we don't need the other part.
So why do we need 13?
I believe the thought was that musical instruments can be mass-produced, and musical instruments that would qualify as art when we go back to section 2-313, because this is fairly complicated, the way that all of these fall together. Certain mass-produced musical instruments, which would otherwise be excluded under 2-314 sub B, could possibly be allowed under the amended sub A sub 13.
Right, but B sub 2, in the red line version that I am reading, B sub 2 includes a new clause at the end that says, however, musical instruments may be included.
That would be any musical instrument.
That would be any musical instrument. So that one's actually broader than 13 in sub A.
That was a concern that we talked about, but the statement under musical instruments may be included is only as, this is going to get more complicated, as an exception to the exclusion, which is sub B. And so then you would go to the allowable musical instruments, which would be under sub A sub 13, so long as it's consistent with section 2-313's definition of public art, which incorporates the definition of a work of art, which is also in that same subsection.
So your interpretation is that 13 controls, and so you can't just buy any musical instrument, it has to be relevant to the art?
That is correct.
Okay, all right. So I appreciate the discussion, I appreciate the proposal for the amendment, and I'm glad to get my head sort of wrapped around some of these issues, but I'm not going to support this amendment.
Okay, are we ready to vote?
I've got some questions.
Go ahead.
When was the last time this was updated again?
Prior to this?
You mean like today?
Yeah. It was written in 2009, and this is the first update.
2009. Trying to think of where I was in 2009. Okay. And does Hawk Island have a sound garden, or does Patriarch Park have a sound garden?
Patriarch Park has some xylophones as a part of the playground equipment.
Okay, all right. Well, you know, and it took time for you all to go through this, and you included the attorney, the city attorney, to make sure, you know, that we weren't erring in any way. I love art, so I used to, during some prime time of spoken word, we had a really active community here in the city of East Lansing, and it's beautiful to see that written word is being honored in this update as well. And the music part, you know, when I think about children and when they hear their voices or see what they can do in the musical parks and with these instruments, I think it sounds really cool. And the other part is paying people. I would love to show up to an event if the artist, you know, because we found an artist who could teach us something about art. I go to those wine and canvas paintings, and I crochet at home and stuff. And so I really appreciate the work that you all put into this, and believe in, you know, the advancement and offering cool things like this in the community. So I'll be voting yes. I'll be voting no on the current amendment.
Okay, let's do a roll call vote on the amendment, please.
Councilmember Altman?
No.
Councilmember Meadows?
Yes.
Councilmember Watson?
No.
Mayor Pro Tem Singh?
No.
Mayor Brookover?
Yes, the amendment fails. Okay, then I would move to amend section 2-314, paren B and paren 2 and paren by striking the language, quote, however, musical instruments may be included, end quote, really for the same reasons I've set forth before. Is there a second? Seeing none, the motion fails. Now we return to the main motion. Any further discussion on the main motion? Okay, all those in favor of the main motion say aye.
Aye.
All those opposed? Aye. Motion passes 4-1. Okay, we now move to, well, let's see if we can get through this. Yeah, let's go ahead and take a 10-minute break, please. Item 5.3, consideration of a policy resolution 2025-1, which would streamline the scheduling process for city council public hearings for special land use requests. Mr. Bartley.
Thank you, Mayor. Just to note, this resolution was meant to be numbered 2025-2, minor clerical error that was originally listed as 2025-1. So I just request that if you adopt this motion tonight, or with a motion, it would be to adopt policy resolution 2025-2.
Okay.
This is a resolution that, if adopted, would allow staff to schedule council's public hearings for special uses. So right now, our zoning ordinance currently requires city council to host a public hearing for special uses and rezonings, in addition to those hosted by the Planning Commission. Our zoning ordinance requires that council schedule its own hearings for rezonings, but does not require such a step for special uses. Staff is always looking for ways to improve and streamline the development process, and adoption of this resolution would do this, and happily without any, I guess, reduction or without removing any opportunity for public oversight or comment. So, Councilmember Meadows, you made a great point earlier this evening, asking about a consent agenda item that scheduled a public hearing and why was it taking so long. Had staff scheduled the hearing, it would have reduced the process by about 2 weeks. In other cases, we found that doing this would streamline the process by about 4 weeks. And then in months when council meets only once, like July, August, November, December, this could potentially save the process 6 or more weeks. So I'm love to answer any questions about this resolution or what we hope to achieve. Thank you.
Questions?
I do have some questions. Actually, for Tony first, though. This resolution has us delegating council authority directly to staff. And they are not, I mean, we are obviously the city council and the legislative group under our charter, but staff is under the supervision of the city manager. We have in the past delegated council authority to the city manager directly. Are we able to delegate directly to staff as a city council? That would be supervising staff.
I don't think that's the circumstance. I don't think that's what's happening in this particular circumstance, because it was never specifically a task of the council that you're formally giving. It was just a practice. The reference that Landon made is accurate, and that the zoning ordinance only requires the scheduling of the public hearing by this public body for a rezoning public hearing.
Okay, well, I got a couple of questions on that as well. You know, it makes reference to 50-31, I think, in the staff report anyway, and that does require the commission to hold a public hearing. And then it says the city council shall, on the receipt of the report of the planning commission, set a date for a public hearing for consideration of such proposed amendment, supplement, or change. So there's a direct requirement for the city council to set a public hearing. In the other section that is referenced, it provides that the planning and zoning officials shall schedule and publish notification of a public hearing before the planning commission. So there's a specific requirement for the planning commission to, again, hold a public hearing. The language relating to the city council says, the city council shall hold one public hearing with notice thereof in accordance with the requirements of section 103 of the Michigan Zoning Enabling Act. That's under a section that says city council review and action, which seems to me to mandate that we hold a public hearing and that city council set it. So the underlying theory here that we are not required to have a public hearing or set one, I don't think is supported by the language of our ordinance. And another question I have is, why would we do this by resolution? Why wouldn't we just do a change to the ordinance if we're going to go in this direction?
So it's the MZEA that does require a public hearing for this special use. There's no doubt about that. That's how our ordinance is written as well as part of the model zoning ordinance. And this doesn't propose to change that at all. It's just that the reference section says that the city council shall hold a public hearing. It doesn't note that it shall set a public hearing similar to the other section you noted in the zoning ordinance for changes to the zoning code, including the map. And so where the sole obligation is to hold the public hearing. What we've historically been doing is bringing back a consent agenda item to set it, and we wanted to simply change it to that piece to solely administrative, and we thought that the best way to codify that change, it doesn't need to be within an ordinance, but we thought a policy resolution to show that it was approved by council to set these hearings by that manner was the most appropriate.
But what is wrong with the current policy of the city council just simply when they receive the reference from the planning commission, taking as their next action to set a public hearing? It's only for special use permit, cluster development, neo-traditional, or a PUD. So it doesn't even cover everything that we do. And the Section 103 says it'll be no less than 15 days prior to the public hearing that the notices go out. I don't see why we would be making this change. I guess I'm just concerned that we would be delegating to staff something that doesn't need to be delegated, and plus we have a built-in limitation, because if the city does not act to approve, modify, deny, or defer the application within 20 working days, it's approved. So, there's a 3-week, I guess, window there for us to have a public hearing on this, which we can defer, we can take action on it, but if we don't take action on it, it's actually approved by operation of our statute and our ordinances. So I guess I'm not clear on, are you recommending that we go down this route? It says that you approved the resolution as to form, but I didn't get anything about the content.
Yeah, because of the timing efficiencies that were referenced by Landon, the timing when we have 1 month between council meetings and we have to set a public hearing and put it out that much farther, then we could have a lot of efficiencies by simply, obviously will properly notice the meeting. We put out the agenda consistent with the Open Meetings Act. It will have the notice of the public hearing on it. We'll follow all the notification requirements to individuals that are set forth in the MZEA. And so when council comes to the table to hold the public hearing, you'll still be equally aware of everything about it. You'll have the staff report, everything like that. We wouldn't just have the additional step of the consent agenda item setting the public hearing. Again, for the obligation under state law is 15 days, and so we can schedule it a lot shorter than sometimes would be allowed by subsequent council meetings. That's the only thing that this purports or tries to do.
Those are all my questions.
Other questions for staff? Yes, sir. Dr. Altman.
So our practice has been for the council to set the date for an SUP hearing, right? That's been our practice.
That's correct.
But it's not required under the ordinance.
Correct.
So how did that practice arise? Okay, that's one question. And for zoning changes, right, the zoning ordinance requires that we do set the date. So why does it do that? What are the benefits of that that might transfer to the SUP case? So I'm trying to avoid throwing out the baby with the bathwater here. I understand the efficiencies. I understand tightening up the timeline, right? That's always a goal, right? Developers are interested in that. We're interested in that. But why were we doing it the way we were doing it?
I think that predates both of us.
I'd be speculating. I'm sorry. I'm happy to speculate, but I don't know
Well,
why.
I would like you to speculate. Please speculate.
My speculation is that when this was established, there was an interest in having, I guess, as much opportunity for public review and as many opportunities for the council to see the application before it came to a decision point. And even though it's somewhat buried, could be potentially buried in the consent agenda, this gives the council the opportunity for just that. However, I guess beyond that, it's hard for me to understand why. I guess I've not worked with a city that does it this way otherwise.
Other questions for staff?
I have a comment, which is that I understand that from the developer's perspective, time is money. I think from the community's perspective, time is understanding. And having more time to understand and review and get used to the idea of a particular special use or other zoning change, that has a value in my mind. So that's just a general comment.
Any other questions for staff? I move that we approve Policy Resolution 2025-2, a resolution to streamline the scheduling process for City Council public hearings for special land use requests. Is there a second?
Second.
Okay, second by Singh. Discussion on the motion. Any further discussion?
I'll be voting against it. I do interpret this language a little bit differently, and based on past practice in particular, that when we have the language within the a heading of City Council review and action, that when we say the City Council shall hold one public hearing, it means the City Council will put appropriate notice out and hold a public hearing, that it doesn't leave it sort of in a vacuum as to who is going to do that. So I'll be voting against the motion.
Okay, any other discussion on the motion? Can we have a roll call, please?
Councilmember Altman?
Yes.
Councilmember Meadows?
No.
Councilmember Watson?
Yes.
Mayor Pro Tem Singh?
Yes.
Mayor Brookover?
Yes, motion passes 4-1. Next matter before us on the agenda is item 5.4, consideration of a resolution to execute an amendment to the cost-sharing agreement with the Michigan Department of Transportation, MDOT, for stormwater treatment and authorize the city manager to sign. Yes, sir.
Good evening, Council. Ron Lacoste, Director of Public Works. What you have before you is a resolution authorizing the city manager to execute an amendment to an agreement with the Michigan Department of Transportation. What this effectively does is in 2018, there was an agreement signed for MDOT to participate in the costs of the sewer infrastructure to treat water in our combined sewer area that goes to the water resource recovery facility. So that portion of Grand River, Michigan, and Saginaw. What this does, in definition of government moving slowly, this project was completed in 2020, the Michigan Avenue project, and it removed some of MDOT's stormwater from our combined sewer system. And we've been working with MDOT ever since to get the agreement modified to reflect the fact that they contribute a little less to the plant. So this is actually a result of a 2020 project, and we're just getting the amendment, the agreement approved. So this just reduces by a slight percent, has about a $30,000 reduction in revenue from MDOT coming into the sewer fund as a result.
Questions for staff?
Can we defer this for another 5 years?
Yes, so they overpaid since 2020, but
that's why I'm asking.
They're not asking for the money back. So,
do we have a motion?
I move to approve the resolution to execute an amendment to the agreement with MDOT for stormwater treatment as identified in the agenda item report.
Second. Moved by Altman, seconded by Meadows. Any further discussion? All those in favor say aye.
Aye.
All those opposed, motion passes unanimously. Item 5.5, consideration of the Valley Court Park and Connectivity Plan. Staff, please.
Good
evening, Council. Kathy DeShambo, Director of Parks, Recreation, and Arts. While our guest who's doing the presentation tonight gets settled, just want to remind you that you did have a little bit of the Valley Court Park Plan and Connectivity Plan in the process of our 5-year park plan. When we presented, we said at the time we would be coming back with the full Valley Court plan, and that's what we're here for tonight.
Good evening, Council. Heather Pope, Community and Economic Development Administrator. I'd also like to introduce Bob Ford with Spalding D. Decker. He's the consultant that we work with on this plan. This evening we are here to present the plan. It's a plan that includes some improvements to Valley Court Park and the surrounding corridors. This plan did go through a public engagement process and was also presented to the Parks Recreation Advisory Commission along with the Downtown Development Authority. Both of those, that board and commission did support the plan as presented. I'm going to turn it over to Bob now, and he will walk you through the presentation.
Thank you very much. It's a pleasure to be here once again, and it's been a delightful process going through the design of Valley Court Park and the corridor that leads to Valley Court Park. The presentation will go through. Okay, we had some project goals, which you can see here. We looked at the history, site analysis, engagement with the public, and we developed 3 concept plans and then the final master plan that you'll have to see tonight. Okay. We looked at the study area and we did some analysis. First of all, the project area. We looked at the zoning, we looked at the historic districts, the utilities, and the different views from the corridors as you're moving through the corridors and also as you're approaching Valley Court Park. These are just some site analysis of vehicular and pedestrian circulation areas and where people are crossing roads, things of that nature. Okay. And then we looked at the infrastructure and evaluated what was good, what maybe needed some repair, things of that nature. Okay. The public engagement process, as was mentioned, we had the 2 meetings. Both were fairly well attended. We got a lot of good comments. And we did a dot voting exercise where we put the 3 concepts that we developed and allowed people to voice their presence, and we took notes. At the same time, they got to symbolize their preference by placing these dots on the various images or plans, but also the things that were included within the plans. Okay. This is one concept, early concept, all right? Second one, and third one, right there. Okay? So I'll take you through the selected components of the master plan and the one that they favored the most. And it involves an oval that goes throughout the park. One of their major requests was to preserve the green lawn, Valley Court Greens, as I like to call it. And they seem to favor that a lot. They want places to walk. They want farmers market to stay there. They wanted different exhibition areas where they could have large events and performances. A little bit of sports activities and to enhance the views to and from and the entranceways in and out of the park. Okay. Another view here, we'll just go through a series of views. I'll take you around and walk you through the overall concepts. This is at the end of Abbott Road where it comes down and meets Valley Court and the drive. And so this will be the enhanced entry. So you'll have a major entry into the park on sort of this eastern front. Okay. Basketball, we have basketball now, it's in poor shape, but we'll redo it and put it in an area that makes a little bit more sense and preserve as much of that vegetation as possible. Okay. The farmers market, which happens on Sundays, is down there, and this is designed to kind of fit that use right now. But if it were to expand, we could expand on both sides of the walkway as far down the walkway as needed if other vendors wanted to display. Okay. And then at the sort of the northeast end of the park, We're suggesting that there be a shelter which would duplicate as an amphitheater. And for large performances, we'd be able to host quite a large number of people in that huge lawn area. All right? And then if there's, we'll do a shade study and add additional shade sails along to sort of shade that area if needed. Okay? On both sides of the park, we're doing an ecological approach and putting in rain gardens so that the water that concentrates and kind of pools at times within this area, it's a basin basically, would then be able to shed to both edges, and on the edges we'll create some very unique planting areas and start to interpret what the water recharge is all about. Okay? Another view, we'll have the ecological on both sides. Then this is the far west end where the playground will be relocated to this area, and it'll allow children to gather there, and also this area would have a small stage by the Board of Water and Light House that was preserved and enhance that stage area. So this will function as either a second stage performance or a smaller performance for children and younger people. All right. Another view looking the opposite direction. And now we're in the center where the farmer's market is. The bollards can be removed for emergency access and also for loading or unloading vendors' wares. And then a restroom is located in the center of the park, which we don't have one now. Okay? This is an example of the setup. Okay? And now onto Albert Avenue. And as you move down towards Valley Court, this would allow us to put in different types of wayfinding and also artistic panels and different types of art forms, as well as lighted bollards, and to separate pedestrian and vehicular traffic. Okay? This would be the crosswalks, and we would highlight the crosswalks, make them very visible and easy to get to and from. This is an example of staining of sidewalk or existing concrete, so it could also be a decorative form, as well as the landscaping and adding trees within this area. Okay? And then the little connection up at the east end, at the end of Albert, could be enhanced. That property will soon develop, but while it's not developed, these could function as little gateways. Okay? And then signage off of Delta Street as you come into the park on the secondary entrance to the park. Okay? And here's more of an enhanced view with the decorative crosswalks and sculptures and entryways in and out. Okay? And that's pretty much the overall concept for the park.
Okay, thank you, sir. Questions? Yes, sir.
So I like this design a lot. It was not obvious to me from the presentation that that was the winning design, the oval. It didn't say anywhere what the vote tallies were or what the winner was. I think I looked through it a couple of times.
I'm sorry, I'm having a hard time hearing you.
Okay. It didn't, I had trouble telling which was the winning plan.
It was favored for number C, but B was a close, runner-up. And then after discussing with staff, and then also taking a look at what the opinion survey had to say from the 5-year master plan, where this was talked about as well, it favored C when we were all said and done.
So that makes sense to me. I'm not sure it says that explicitly in the plan. And
we can make mention of that.
Because if it's a plan, then people are going to refer to it down the road, and it would be useful for them to be able to identify clearly what was the winning.
Yeah,
we'll
make that correction.
I think that was really my only. Oh yeah, did you connect with vendors to ask them about the design of the pavilion to make sure that that was going to meet their needs?
Yes, as a matter of fact, I attended 3 farmers markets, and each time spent time with them talking about how they view the situation and if they would like to stay there or relocate to some other location, and what we could do to help improve the situation. So from those questions, we were able to gather that, first of all, they wanted to stay in this location. They like it very much. They thought that expansion would be good, but they didn't want to expand too much. They're pretty comfortable with the way it is right now. And they wanted to be able to get their trucks in and out and get the trucks out of the way so they could load and unload, hence those bollards and accessibility.
And in terms of the height of the pavilion and the space between the pillars and so forth, are those sorts of parameters things that you're confident in will be appropriate for the vendors and will sort of maximize efficiency while also maximizing ease of use?
Yeah, I think it'll work fine. We've done a number of markets, some very large markets, some very small. This one is more on the small side, but we also realize that there might be an opportunity to expand into the future. So that center oval walkway provides ample space to maybe expand in the future if needed.
Thanks.
Thank you.
Other questions? Yes, ma'am.
We're losing the tennis courts. I know they're not in good shape.
They're in terrible shape. Yeah.
And basketball won out over tennis.
It did. But there was a discussion. It's not to say that it was just discarded out of hand. The amount of usage that it gets compared to basketball was the main factor, and the age population in the immediate proximity in that area seemed to favor basketball more than tennis. And there are other tennis courts within the city that people could go to. Tended to be more of a downtown thing, whereas tennis needed to be with other courts such as Patriarch Park or things like that.
And that's what I was curious in terms of usage at other tennis courts. And I know it's just 2 courts that existed, but it's helpful to understand that public opinion and usage favored basketball. Are we losing any parking spots in this neck of the woods in the proposed plan? I see Heather saying no.
To do what again? On the
Parking spots?
Additional parking?
No. Are we losing any parking spots that
no,
are?
You're really not losing any spots at all. Some of the spots on Sunday are used by the truck vendors, food vendors. Those would be, and that's going to continue as far as I know.
Okay. I just, again, people's church congregation members have voiced concerns about some of the parking, so I would just wanted to connect on that.
Yeah, no loss of spaces. They'll remain pretty much the same.
And then my last question is, in terms of, you're going to be relocating some equipment, I'm just curious, like, from a budget standpoint, was this like, if budget's no worry, or we're able to relocate existing pieces within the park to the new location? I don't know if there's any cost savings within figuring to leave things in the place. I'm not articulating this very well, but.
Well, budget is, of course, always a factor. We try to estimate the best we can based on a proposed concept of what the cost will be to renovate. There's a number of issues in this park that a lot of people said, there's nowhere to go to the bathroom. So you've got to provide the bathroom, is what we heard pretty loud and clear, and that's very typical. And then you also have to think about the under drainage for this area, because it is the basin. It does collect the water from all around the area. So we're proposing that we put in a drain field underneath the field, so that will drain to the sides and making it a little bit more usable, and also utilize some of that water, hopefully for irrigation as well. As far as the costs, they are what they are to make this plan work. It can be done in phases, so it doesn't have to be done all at one time, so you can stretch it out. And there's also grant funding that was available for the park, and hopefully that'll be resurrected, so we'll be able to get a good jump start on it and prioritize those items that are most important.
Yeah, I guess that's probably what I was getting to in terms of if it is phased, or if there's if we leave the play equipment where it is, how does that impact the master plan, as an example? So I was just curious about relocating the basketball court. Courts are not cheap to put in, so.
No, they really aren't cheap. That's something that could linger you know. I think that the restroom and some of the immediate facilities would be a big improvement for the
Yeah.
park. The oval is something that was stated over and over again throughout the 5-year master plan process for pretty much the whole city, but in particular within the downtown area. And the sorority to the north side, we talked to them. They said the bothered lighting that you're proposing around the oval is ideal for silhouette lighting, added to the security so the ladies can move back and forth without too much issue, things of that nature. So we're trying to take into account not only the whole big picture of the city and park development, also the immediate users and adjacent landowners as well.
That's great. Thank you. And I too love all the green and prefer what you've proposed to prior plans. So thank you.
Other questions?
Yeah, just
Yes,
a
sir.
couple of questions, particularly with regard to the band shell and the raised stage there. There is one picture here showing somebody playing a fiddle and people sitting down there. Can you tell me how much higher the stage is than the adjacent land that people would be sitting and standing on?
Yeah, generally, we'll have to do a little bit more in-depth study before those elevations are actually set. This is a master plan, so the details still have to be fleshed out, but generally speaking, you're between 3.5 to 4.5 feet above the ground. You can terrace it also, so that you can have stairs or benches out in front, so also a handicap accessibility to that. So we don't want to get too high, but we want to get high enough so the view angle is seen. Once you get a certain distance away from the stage, it's less about the view and it's more about listening to music anyhow. But within the first 200 feet, you want to have a clear line of sight. And you'll be able to do that. I'm thinking even less than that. I'm thinking 3 foot would be all you would really need in order to make the performers visible from quite a ways away. So those details will be worked out, and that will be studied with cross sections and view angles and also sun angles to try to shade not only performers but trees around the perimeter that would help shade people as well during the heat of the summer.
But we have the band shell cover in this plan, and I'm just thinking of our survey for the Folk Festival, which overwhelmingly said bring music back to Valley Court Park. Did you analyze how many people, for instance, can be held in this oval that comes off the stage?
It depends. You mean for the audience?
Yep.
It'll be quite a few. I'm hesitant to say a number because it depends. If it's lawn seating with blankets or if it's you bring in lawn chairs and things of that nature. We usually figure that it's about 6 square feet per person, but if it's a popular band, you're going to have a lot more people in that 6 square feet. But
Well,
that's what we think.
historically, anyway, the Folk Festival has had people shoulder to shoulder in there, so
Yeah.
that's
Yeah.
why I'm asking.
Yeah, I mean, you could have probably a couple thousand people down there easily.
Okay, that's good news. No, I really like the way that it's laid out. I realize that we may be losing an amenity, namely the tennis courts, but I confess I've never seen anybody playing tennis on them in recent years anyway. I'm
Right
sure
now,
people do,
the ball
I
won't
haven't
hit
seen it.
square on the pavement right now. It's so eroded, you know. It's not functional.
And I hardly can go down there where I don't see people playing basketball as long as cars aren't parked on the basketball
All the
court. So-
time, I noticed the same thing. I spent quite a bit of time myself personally. It's right on my route. I stop in, different times of the day, see what people are doing. Generally, it's casual use.
Yep.
And then there's the peak use.
So looking forward to this.
Excellent. Thank you. It's been just a pleasure working on this project. I can't tell you how much I've enjoyed it.
Other questions? I do have some questions for you.
Sure.
Segueing back to Dr. Altman's inquiries.
If you could speak up, I'm sorry.
I'm sorry. I just have a couple questions for you, segueing back to Dr. Altman's inquiries. So in terms of the data set here, so how many people responded to these surveys or to your DOT exercise?
There was probably in the neighborhood of 7 700 to 800 people.
Okay. And then, did your organization have specific contact with the Forster Woods people?
That's the area right adjacent?
Well, Forster Adult Day Center?
Yes, we stopped in and talked to them and asked what the impact might be. Nobody gave us, I wouldn't consider it really good information. They said that things are functioning pretty good now, and as long as it doesn't change, and they had access to parking is all we really heard.
Okay, well, you have number 14 is this, I think you call it the turnaround area. Did you talk to them about whether their bus that delivered the people to the Forster Daycare Center would have enough room to turn around in that space?
Yeah, that's designed so a fire truck and emergency services vehicles can turn in that radius easily. So it meets all the demands other than maybe a semi.
Okay, and then we're losing that contingent parking or contiguous parking that's there now, correct? Where the basketball courts are.
Yes, thank you. That we are losing that, that's right.
Which is what, 30 spaces maybe?
Well, it probably is, but honestly, I haven't seen too many people parking there. The most I ever counted was 12.
Okay, all right. Thank you, sir, I appreciate it.
You're welcome.
Okay, anything else? Okay, does the council wish to do anything with this tonight?
I move approval of the Valley Court Park and Connectivity Plan.
Second.
Okay, moved by Alderman, seconded by Meadows. Discussion? I'm going to be voting against this for the simple reason that I just don't believe in replacing grass with concrete. If this did not have this oval walkway, I would probably be in favor of this, but I think this is problematical because it destroys potential play spaces, and I think there's a value to just an open space in downtown East Lansing. So understanding that I'm going to lose on this issue, but I am going to vote against it because I think we should have preserved all that green space if we could have. And the fact of the matter is, at least on the south side, we already have existing sidewalks, so people can walk on that sidewalk and enter the green space from that sidewalk. And they can also walk around on the other side and enter from through the turnaround space in that area. So I appreciate all your work and all your effort in this. Okay, any other discussion? Okay, all those in favor say aye.
Aye.
All those opposed, aye. Motion passes 4-1. Thank you, sir, appreciate it. Okay, next item is, let's flip back to my agenda here. Item 5.5, consideration of, excuse me. Here we go. 5.6, consideration of the regulatory status of a sub 2-acre wetland located at 2447 Lake Lansing Road. Cliff.
Thank you. Cliff Walls, DPW. As you mentioned, we're here again about 2447 East Lake Lansing. If you remember, 2 weeks ago, we discussed the determination before you, which is whether this wetland B is to be considered essential to the preservation of the natural resources of the city or not. The regulatory status of the wetland depends on that determination. Essential means regulated. Non-essential is not regulated. One of the questions, or among the questions from the last meeting, were an expansion of the rationale from the ASTI wetland consultant. And you'll notice that the agenda item report has been expanded, both in my memo and then also their memo. So I guess I don't have the page numbers on my printout right here, but ultimately, there's three main things that ASTI wanted to communicate more clearly. One is that it is their professional opinion that this wetland B was likely not a wetland at the time of construction of the Rite Aid, and that the hydric soils that are now present weren't there 20 years ago. So based on that conclusion, or their theory or professional opinion, they believe that it would be subject to, I believe, I have it pulled up here, there's an exemption in our ordinance and in the state ordinance. It is 4910, activities not regulated under this chapter. Number 3 is a wetland that is incidentally created as a result of one or more of the following activities. D is a stormwater treatment, detention, or retention basin created in accordance with state or local requirements to control the rate of stormwater runoff, on and on. Based on their records review of the 2005-2006 plan that we were able to locate, it did not indicate that wetland B was called out by Eagle at that time, even though wetland A was, and there was a stormwater discharge permit for the area of wetland B. All in all, leading them to believe that it was not a wetland then, but the construction of that depression has created a wetland now, and it's likely exempt. The other question that was brought up was about how can, or the 10 ordinance criteria which are prescribed by the state. Among them are 2 that had particular interest of the council's discussion last time. One was about habitat, how could it not provide habitat? And the other one was stormwater detention, how could it not provide stormwater functionality? And that's clarified in their memo. Basically, the habitat, while they acknowledge that any environment is likely to house plants and animals to perform as habitat, they're looking for unique, rare, and otherwise essential species. They noted in their opinion that it's a low-quality wetland that has a lot of invasive species in it, and so it doesn't meet that typical, in practice, how that standard is applied. And then for stormwater, they also acknowledge that by their nature, any wetland is going to function to control and contain stormwater. But when they consider if it's essential or not, they're looking at what would happen in the absence of it. Because in their view, wetland A is immediately downstream of that. The absence of wetland B would not adversely impact the area. That would be absorbed by the larger, higher quality wetland. So I wanted to make sure that you had that context, which I will be more clear in the future to have that more clear at first. So apologies for that. And I want to make sure I got a lot of different tabs open to keep track of all this. I don't know if you want to just go with discussion and I take some questions. I do know that the applicant is here. I don't know if you're going to have any questions, but I just want to make you aware that there are people here that would have that specificity.
Questions for staff? Dr. Altman, I think those are really your questions. Do you get answers to them?
Yeah, I appreciate the answers, and so I've got the information I need. So thank you for reaching out to the consultants, and I appreciate their elaboration.
Any other questions for staff? Okay, what's the pleasure of the council?
So I have a motion.
Yes, sir.
I move to determine that the .44 acre wetland at 2447 East Lake Lansing Road is essential to preservation of the natural resources of the city and is therefore regulated by the city of East Lansing.
I second the motion.
So
discussion.
If I could address my motion. So this was the recommendation of the Commission on the Environment. It's a unanimous vote. I think creating a wetland is a perfectly good way to get a wetland, especially since we've lost a lot of wetlands. And so creating one is good. And it's, I was concerned at first about the invasive species issue, but in fact, I believe under the wetland ordinances, we're planning to revise it. Remediating invasive species is one of the things we can do to improve the wetland in the future. And this is going to be a long-term designation that will prevent any future project, decades from now potentially, from tampering with this area. So I'm thinking of this as a long-term step that's consistent with our concerns, my concerns about stormwater and environmental preservation.
Okay, other discussion?
Just a confirmation that our designation of this as a wetland doesn't affect the construction that is being proposed for this particular location, right?
So the proposal that we have is, it hasn't undergone the full wetland use permit review. But as I mentioned last time, there's not the traditional way you'd think of a physical impact in terms of filling or occupancy of the wetland. I think it may require some shifting because there was a setback within 2 feet of our 15-foot flat work setback. But I would anticipate, other than just the administrative, the added, administration that, this would undergo, it would not functionally impact the ability for this project to proceed. One thing I do want to highlight that was mentioned in the memo as well is because half of this is a stormwater pond. There was concerns from ASTI to whether, or regulating it, in their view, may complicate stormwater detention pond maintenance because it may be a regulated activity when they're going in to do their dredging, which is something that they would be required to do under their Ingham County Drain Office permit, or I assume they will typically have a maintenance agreement. So it may be something the city would have to navigate in the permitting process because it is a wetland, it has the hydric soils and meets that definition. But a good chunk of that is actually a, man-made stormwater facility that has maintenance needs to perform as it should. So that just may be something that the city would need to navigate. I don't know off the top of my head if in our permitting process, if there's, I know it references those as being exempt, but if the city does regulate it, I'm not sure what the requirements would be, or if there's further exemptions for something that is regulated, but also will have those competing challenges of another jurisdiction, just to maintain its functionality. I don't know if that even makes sense to you.
Can I, just as a follow-up, just so I think I'm hearing what you're saying, that if we regulate it as a wetland, then it puts in jeopardy the Drain Commissioner's right to tend maintenance to the stormwater basin.
That is something I have not encountered, because typically those are exempt per the ordinance. And this is not something that we have that guarantee, it's not proven, it's just a professional opinion based off the records reviews. But the applicant, from my assumption would be, like any other applicant who goes through stormwater permitting, they'd have a post-construction maintenance agreement. What you do is, they require certain levels of detention or infiltration, but these are systems that are, getting leaves and mud buildup, and so they require some maintenance. Mm-hmm. And so if their permits require them, or their maintenance agreements with the county required them to dredge the detention pond on a 5 to 10 year basis, which is typical, that would maybe then trigger a wetland use permit from the city if we're considering that facility to be a wetland. But it's something that I've never encountered. That's kind of why I just wanted to bring it up. And it's something that they referenced in there too. But in terms of the functional impact of that, I'm not sure how that would play out.
And if I could just confirm two other things you covered earlier. One is 20 years ago, this wasn't a wetland.
That is what the professional opinion of the consultant is. So their assessment, yes. I can explain why, but it's one of the definitions, or one of the 3 criteria to be a wetland is hydric soils. Mapping from before, which is kind of general, like the state has this database of where these soils are.
Yeah.
Their assumption, or the records show that wasn't mapped at that time. Now they're seeing them. So the assumption is that the creation of the stormwater facility there resulted in what now qualifies as a wetland. That's their professional opinion.
Okay. And then just, and you mentioned if we did not, I forget your language here, but regulate it as a wetland, it would not adversely affect the other wetland, neighboring wetland that is actually a regulated wetland.
Yeah, so the wetland A, or the large wetland that you can see on the map over there by Costco is part of like the Costco mitigation wetland. It's much larger. And what their assessment is saying is that they did not deem wetland B to be essential because that water could be absorbed by the nearby wetland. So that's what they're saying with that. It's not in the memo either, but they did communicate with us that wetland A is drier than they would like. And so overflows from B, whether it's regulated or not, that's separate from that. But more water to that is a desirable condition from the perspective of the
Seems
city.
really important, Cliff.
Well, it's not related to, it's not dependent on the regulatory status of this.
Right.
Just saying that when this design overflow occurs, no matter, what its regulatory status is, that's not harmful.
Okay.
It's actually not bad. It's a good thing.
Okay.
So I think everything's perfectly clear to me now.
Yeah, this one's not normal. I will give you that. It's hard to articulate.
So the bottom line, Cliff, is it's not normal, right? I mean, that's, okay. Any further discussion on the motion?
Just one more question.
Yes, please.
And the applicant is in favor of it not being essential. Thank you. And the vote on the floor is that it is essential.
Correct.
That's the motion.
Thanks.
Okay, could we have a roll call vote on the motion, please?
Councilmember Altman?
Yes.
Councilmember Meadows?
No.
Councilmember Watson?
No.
Mayor Pro Tem Singh?
No.
Mayor Brookover?
Yes. Motion fails 3-2. Is that sufficient then? Is that sufficient? Do we need an affirmative motion now?
So what I would request is an affirmative motion, which is the alternative motion that was included in the agenda item.
Mr. Meadows, do you have that in front of you?
Wasn't that an affirmative motion?
Let's just do it the way the city attorney requests. Do you have that in front of you? I can do it if you need it. Do you have it?
Okay. Yeah. I move to deem,
To determine?
to determine the regulatory status of the sub 2-acre wetland located at 2447 Lake Lansing Road as non-essential.
Is that the motion you want?
Well, motion to determine.
Hang on.
Okay,
Is that the motion you want, Cliff or Tony?
It's the item that's in the agenda package.
Could I suggest, with due deference to you, that the motion is to determine that the .44 acre wetland at 2447 East Lake Lansing Road is not essential to preservation of the natural resources of the city and is therefore unregulated by the city of East Lansing. Does that work?
Yeah, second.
Okay, moved and seconded. Any further discussion? Roll call vote on this one, please.
Councilmember Altman?
No.
Councilmember Meadows?
Yes.
Councilmember Watson?
Yes.
Mayor Pro Tem Singh?
Yes.
Mayor Brookover?
No. Okay, thank you. We are at the close of our regular agenda. Do we have a motion to go into closed session at this point?
I have a motion pursuant to MCL 15.268 sub 1 sub E to consult with the city attorney in closed session regarding trial or settlement strategy in connection with pending litigation in Hios v. City of East Lansing in County Circuit Court Case number 20-199-CZ for the reason that an open meeting could have a detrimental financial effect on the litigating or settlement position of the city.
Motion by Altman. Do we have a second?
Second.
Second by Meadows. Roll call vote, please.
Councilmember Altman?
Yes.
Councilmember Meadows?
Yes.
Councilmember Watson?
Yes.
Mayor Pro Tem Singh?
Yes.
Mayor Brookover?
Yes. So we'll adjourn to closed session and then be back.
Has a motion for closed session
Everybody all set here? Do we have a motion relative to coming out of closed session?
I move we return to open session.
Is there a second?
Second.
Second by Meadows. All those in favor say aye.
Aye.
All those opposed? Any further motions tonight?
I have a motion. In the matter of Hios versus City of East Lansing, Ingham Circuit Case Number 200000199-CZ, I move for the tentative approval of the settlement amount as presented by the city attorney in closed session, and further instruct the city attorney to negotiate with plaintiff class counsel towards a settlement agreement that will require subsequent council review and approval at a future meeting.
Second.
Second. Could we have a roll call vote, please?
Councilmember Altman?
Yes.
Councilmember Meadows?
Yes.
Councilmember Watson?
Yes.
Mayor Pro Tem Singh?
Yes.
Mayor Brookover?
Yes. Do we have a motion to adjourn?
Move to adjourn.
Altman moves to adjourn, second by Brookover. All those in favor say aye.
Aye.
All those opposed? Motion passes unanimously. Good evening, people.